Professor, School of Sciences. Welcome you all to this insightful lecture jointly organized by Education Sciences and Professor, School of Sciences. Design Challenge. This insightful jointly organized by Sciences on Professor Design Challenge jointly organized by Sciences on
biodiversity. So there are around more than 10 different types of intellectual property, plant varieties, new plant varieties. So see, these are some of the benefits why we all uh, need to consider IPR in our course curricula. So it fuels innovation. There is enough motivation by view of such IPR so that we can reinvest our monetization in expressing our new ideas. And expressing our new ideas needs a lot of efforts, time, resources, funds. So without IPR, it's very difficult to get monetization. And without monetization, it's very difficult to do some research and development. So if we see whole life cycle, you will appreciate IPR. Without IPR, the whole life cycle is unable to fulfill. So it helps in strengthening economy, it helps in foreign direct investment, it helps in preventing passing of uh, goods or services under others' brands. So there are a lot of benefits. So this why we need till last year we have around over 100 unicorn and approximate value is in around $350 billion. Just imagine. So cross-border innovation is not possible without a strengthening. Just a moment. So these are two quotations, one from our Honorable Minister of Commerce and Industry and another one from our CG PDTM Controller General of Patent Design Trademark. So our technology and idea serve as the twin engine of growth with the intellectual property design acting as the fuel that powers this engine. And head of IP office, that is popularly called Office of CGPDTR, IP is the fuel that drives innovation and creativity. Protect it fiercely. If I have opportunity to rectify, I wish to add one more words in this line, rights. That is intellectual property rights. It's not only intellectual property, it should be intellectual property right as per my understanding, because all the times you all people create or innovate something which may be eligible to be considered as intellectual property, but mere having intellectual property is not enough to fuel, to drive innovation and creativity, because it needs motivation. Motivation may comes by recognition, motivation may comes through monetization. So mere creating, innovating things can't help much, but the legal rights to restrict others, not to commercialize, not to misappropriate without the consent of the right holder. So who is the right holder? Right holder is the creator, author, publisher, etc., who have created or innovated some intellectual property. So it's the rights only which gives such power to restrict others. And that's why many times you might have monopoly rights. Again, it needs rectification. This is not the right word. The right word is exclusivity. To exclude other for such uses, for such commercialization, although there is a fair use provisions for academia, for research purpose, to certain extent we can use it. Otherwise, it may be considered either the passing of or infringement of the concerned legal right. So, key barriers, particularly to private research and development organizations, including academic institutions. Ineffectiveness and unaccountability of public R&D spending, financing gap in the innovation life cycle, unavailability and inaccessibility of research and development infrastructure, constraint in developing long-term human capital, and gaps in IPR protection. So we will discuss a lot of things in subsequent slides. Let's move forward. This is a letter from UGC to all the Vice Chancellor in India. See the date of this letter, 15th July 2016. There are two paragraphs in this letter. First paragraph signifies the importance of IPR and types of IPR. You can see here creation of minds such as inventions, design, literary, artistic works involve name, image. So these are the examples of intellectual property that are protected by IPR. That is of two types, industrial property and copyright. So again, the historical backgrounds like 1893, there is a Berne Convention, 1896, there is a Paris Convention for such industrial properties. So it should be encouraged, protection need to be encouraged, and also striking a balance between innovator and public interest by creating an awareness where creativity can flourish. So see the beauty of these two paragraphs. They try to cover the whole philosophy behind this paragraph. So it gives the hint that what is IPR along with the example and types. So you can see there is a word balance between innovator and public. So IPR is nothing but the balancing system, balancing the interest of creator, innovator one side, and another side is public in law. And there's a third party, that is the government, having the duty to balance the interest by such policy and law. So keeping in view the importance of IPR, which recognize the work of the creator, you are requested to devise through Academic Council inclusion of IPR as a journey elective subject under CBCS scheme, choice-based credit system. So nowadays, in most of the academia, there is a one elective paper in IPR. So many times it depends as per the availability of the resource person or the in-house staff. If they materialize, such CBCS is working, and otherwise most of the times we serve in such IP outreach program, online, offline. This is later dated 2025 this year. So UGC again wrote the letter to all the Vice Chancellor all over India that they need to refer this scheme National Intellectual Property Awareness Mission, that is called NIPAM, to skilling students and faculty on intellectual property rights and innovation. So as per this scheme NIPAM, you have options to request for online NIPAM program or offline NIPAM program. So under that program, see the coverage is a basic digital certificate. So there is a provision of e-certificate to all the participants. Participant may be anyone, including students and teachers. So it also do advocacy of formation of Bharat IP Club, a student ambassador. This is just like AICT IP ambassador program on IP. Sensitization of a student to identify counterfeit and pirated goods, guidance on plagiarism, copyright, and proper internet citation. Understanding the importance of IP in India's vision for 2047 as a Viksit Bharat. Competition and activities relates to intellectual property, National IP Awards, participation in Viksit Bharat IP Pledge for innovation and national development. So these are some of the objectives. So if any of you people interested for your concerned academic institutions, you need to contact these two people. One is Jaivi, Assistant Controller of Patent and Design. There is an email ID here. And second one is Nitin Agarwal, the Director of Yuva Manthan. The contact information is mentioned in this slide. You can contact them to organize NIPAM IPR program either online or offline in your campus. So IP office collectively strive towards Bharat attaining developed nation status by 2047, and in this transformative journey, the indispensable role of intellectual property right and innovation will empower both the student and youth, aligning with the Honorable Prime Minister vision that यही समय है, सही समय है. So, can you differentiate these two pictures? One is regarding the fresh coconut water at the rate 30 rupees, and another one is packaged drink coconut water at the rate 120. So the idea is there are two type of people. One is businessmen and another one is entrepreneurs. So there is a difference. The purpose to promote IPR is to create entrepreneurs, not the businessmen. So that with the own creativity and innovations, they can be create their own startups, their own entrepreneurs. They can be entrepreneurs. So they don't need jobs. So it will help a lot for Viksit Bharat. And another, for NIRF ranking, many times we need to arrange filing data, IP filings data regarding how many patent applications or design applications or copyright applications we have filed, how many such applications have been published, how many such applications have been granted, and how many of such applications has been commercialized successfully. So for all such steps, all such numbers, there are certain marks which help to promote any person, including individuals or institutions, both. So there are certain challenges in academia and for researchers too. Most of the time it is noted in Indian context that there is an absence of a dedicated IPR cell or technology transfer office in institutions. Nowadays, since decades, university and AICT, all the times they promote suggesting, directing to have some sort of IPR cell in academic institutions. Nowadays, many institutions have a dedicated IPR cell. Unfortunately, in most of such IPR cell, there is no full-time IP person. So most of the time, there is an in-house faculty who have extra charge for such IPR cell. So it's very difficult to manage the activities of IPR cell and filing IP applications. Further challenge is inadequate IPR training in regular curriculum for science and technology, engineering, design, or commerce stream. So it is in every subject, almost in every subject. So weak institutional IP policy again, or there is outdated rules framed under such institutional IP policy. So difficulty in navigating ownership disputes in multi-author, multi-funding projects, multi-inventors. So how to distribute the benefits. Budget constraint, another challenge to pursue filing, prosecution of filed applications or litigation sometimes arises. Disconnect between academic output and commercialization objective. So there is a gap in industry academic working. So whatever required by industry, many times academia is not working over there, and whatever is the output of academia generally not preferred by industry, because there is a profit motive, and whatever the demand, the focus of industry is on the market, the demand side. So there are some recommendations for academia to establish a robust IP policy with clarity on ownership, benefit sharing, and filing responsibility. There is a need to create a campus-wide awareness program on different types of IPR, particularly in academic context, on copyright, set up an IPR cell with legal and patent expert to assist. So even if we are unable to hire some full-time IP person, we can have a good coordinator so that the person may manage IP service by outsourcing. So provide funding support and incentive for such filings, patent, design, trademarks. There are so many government schemes for IPR that may cover both the government fee and professional charges. So the ultimate cost to academia is zero. Believe me, in subsequent slide I will show how it will be zero. Really zero. There are two type of cost, government fee and professional charges, and under certain schemes all such charges are covered. So encourage IP clinic, workshop and collaborator with incubator and IP professionals. Include IPR education in UG, PG course curriculum in every discipline, whether it's a science or commerce or arts or law or management. In every subject, we need to include IPR. If we can't cover the whole one paper of 100 marks on IPR, at least we may provide one or two modules in one paper like research methodology or ethics, research ethics. In some paper, we can try to accommodate one or two modules on IPR. So for those participants who are first time attending such IP sessions, for them, intellectual property means a creative idea in expression of human mind that is called intellect. And that's why an idea can change your life. So idea may be precious. So ideas, the expression of such ideas like prototype, considered property. And since such property is based on intellect, that's why we say such property is intellectual property. So intellectual property is an asset. It can be bought, sold, licensed, like any other physical properties. So IP is not a tangible property, it's the intangible, but it may be treated like tangible properties, like other properties. So we have some legal rights like exclusive rights. So only the right holder have such rights to exclude other territorial rights. So such IP rights given in a particular territory where you have applied for such patent or design or trademark, etc., you have such legal rights in only those nations where you have granted such IP rights. Those countries where you didn't apply it or you didn't granted such IP rights, you can't exclude people to commercialize, to enjoy such intellectual property. And nowadays, whenever you file anything, government office publish all such applications, so there is no any trade secrets or confidentiality. Once the government publish such things, anyone may access any of such information online anywhere in this world. That means you have to surrender your right or interest in those countries where you didn't apply for such IP protection. And due to having such IP rights, you have to commercialize. Otherwise, this is mere a piece of paper. The certificate, patent certificate or design certificate or copyright certificate, this is mere a piece of paper, A4 size, one single page document. Beauty is you have legal exclusivity in a particular territory. You, if you like, you can assign such rights to someone, just like selling it out. You have rights to license it, just like renting it out. In renting, there is no any transfer of ownership. It's only the rights that other person can use it without claiming the ownership. So these are some of the attributes like expertise, creative thinking skills, and motivations, all such attributes needed for the creativity. So these are the output of creativity. Such output of creativity is considered as intellectual property, and it may include like innovative products or processes, cultural, artistic, and literary works, creative designs, distinctive sign, microchips, denomination of goods attributable to your origin, confidential business information, plant varieties. So all such things are collectively called intellectual property. So these are different types of intellectual property. We need to protect all such different types of intellectual property legally. Otherwise, there is no any benefits investing our time, energy, efforts in such creations and innovation. Prima facie, the owner is the creator, but where a creator is working under certain institutions like academia or companies, etc., as per the work contract, the company, the academic institutions may be the right holder for all such creativity, all such innovations. So it depends, or even if there is no any clear clause in such job agreements, it is implied that the company, the academic institution is the rightful owner, and the person who created such things, invented such things, may be recognized made as a creator or innovator, but not as the owner. So question arises, who can be the applicant for all such IP applications? So this is a frequently asked question in every academia. Many times people have this confusion, who need to take initiative? Whose name will be at the place applicant? Whether the institution can file the application, or whether the inventor, the creator can file the application, or whether they need to club both the institution and the creator, the inventor, designer need to be mentioned in the column applicant. So it depends. Where there is no any clear-cut guidelines, there is a confusion. This is obvious. So it is suggested there must be some institutional IP policy avoiding all such confusion. Although there is an implied system or implied things that in lack of such clear guidelines, institutions' name will be the applicant, and as per the request from the concerned inventor, designer, if like institutions may add their name also along with the institution name in the applicant. My suggestion is we no need to go who is the applicant, who is not. We may request for certificate in the name of the creator, inventor, designer. Such certificates issued by the IP offices. And for the ranking purpose, name of institution must be in the applicant column, and that's why there is no option with the academic institution for the applicant who can be the applicant. And most of the times where applications filed by academia, government fee has to be borne by the academia, not by the individual creator, inventor. isn't it? And again, the professional charges also to be bear by the institution only. In case institute is not preferring to pay such government fee and professional charges, most of the time such inventors do outsource such IP works outside, filing such applications in their own name if they are paying themselves. So I suggest, and as per the IP policy of the country or as per the standard IP policy, all the institutions must have some institutional IP policy whether they should clear if any person from the institution wish to file any IP applications, that institution will encourage such IP application and will bear all the cost, including government and professional charges, and also arrange some appreciation, some sort of appreciation for such initiative of the creator or inventor. Even if such applications accepted and granted, subsequently if commercialized like technology transfer, whatever the monetization gained by such institution, they must share certain profit to such creators innovator. So it may be like 30, 70, 40, 60, 50, 50. As per the convenience, institution may decide. So there is a story regarding this Taj Mahal that the owner of this Taj Mahal, the Shah Jahan, have cut the hands of artisans so that they have these unique monuments, and no such monuments may be created by such artisans. I don't know what is the fact, but the purpose of showing this slide is see the culture or the since the time immemorial, people are trying to protect such intellect by certain tools, and this is one of the way they try to protect such monuments so that there is no any replica later on. Long back in Kotil Arthashastra, they have mentions very clearly in this document that the person who do such efforts, investment, giving such time to create something useful, something unique, which can be considered in benefit for the society, that person must be recognized by such societies, and there may be some monetization compensation to those persons who do such innovations and creation for the welfare of the society. IPR is the same principle, balancing the interest of the creator, innovator, and public in general. So if we don't give respect to IPR and those persons, there is a hardly motivation, and without such motivation, there is hardly any new things, new intellectual property. There will be no any medicine for the new diseases, and that's why we need to give respect towards those persons who create or innovate such things which is useful to the society. So IPR are the ownership right you have over things that you create as a result of your original ideas. So ideas cannot be protected. Many times we discuss ideas. Ideas per se cannot be protected. Can you stop any person that no, it's your idea, how that person thinking their ideas? So we can't control others' mind that way. So in order to protect such things, we need to work on the ideas. We need to express the ideas. And whatever the expression of such idea, such expression may be eligible as a intellectual property that can be protected as per the kind of property. If the expression is some form of invention, there is a IPR, that is patent. So subject matter for patent is invention. Similarly, if there is a artistic design of any article, we may protect such artistic design of that article under industrial design. Similarly, if there is a literature, drama, music, artistic thing, we can protect such things under copyright. So as per the kind of subject, we can protect such things under different kinds of IPR. And this slides where there is a 127 crore compensation awarded against the Maharashtra government, that is the Bombay High Court ruling, which is upheld by Supreme Court in this year only, January 2025, where they allowed a Dalit couple to receive compensation for the destruction of their intellectual property. So this Dalit couple did some research, and the research data is stored in their laptop, and there is a damage to that laptop by certain people, and against those people there is a suit filed under SC and ST Prevention of Atrocities Act 1989. So the court considered that data like a property, and destruction of such property, they give compensation of this 127 crore. So you may appreciate by this case how court is deciding such IP matters, giving equal rights like a property rights for the data and information which can be considered like a precious property. So nowadays, due to frequent litigations in the field of IPR, there are a specialized bench or division on IPR in different high courts. So far, there are 3 division courts on IPR, one in Delhi, Mumbai, and this third one is in Calcutta. So see these slides where there are different expressions in one sentence, like all I asked was, can I patent my copyrighted trademark? Being a practitioner, many times all the practitioners have such experience that people came to them and ask the question like, we need patent for my logo. So logo can be protected under trademark because logo is the subject matter for trademark. And subject matter for patent is invention. So invention cannot be registered under trademark, and trademark cannot be registered under patent. So we can't use such multiple IPR in such a way. So this is a very funny slide for the practitioners and those people who know such differentiations in different kinds of IPR. So these are different kinds of IPR, and IPR is an umbrella term which covers all such different kinds of IPR. So now if there is a person who is having confusion regarding having some innovations and how do he protect such innovations so that he may exclude others in the market. So there are different options with them like GI, trademark, trade secrets, copyright, design, patents. So how we may guide? So we have to ask few questions. And first question is, what is the subject of your innovation? What is your innovation? So as per the kind of innovation, we may help them. Okay, you have to proceed for this particular intellectual property right. So these are different subject matter like design of any article. Such article may be automobile, air condition, washing machine, chair, fashion articles, textile articles, jewelry articles. So it can be anything, any product. So the look, the aesthetic design of that article is one of the type of intellectual property that is called designs of that article. Literature, literary items like book, journals, articles, multimedia, recordings, software, business method, process, fine art, performing art, broadcast, recordings, all such comes under one category of intellectual property. Another category is vocal for local. So there are local items in every place which are famous due to certain attributes in such local item, and that's why they are so famous that even in remote areas outside other states, even in foreign countries, people have awareness about such a specific item from some local area. So there is a demand also in other places. Other categories is marks which we use to promote our goods, our services. And such mark may be like logo, name, the word, expression, tagline. So these are again another category which is comes under the mark. Layout design of integrated circuits, plant varieties, inventions. So all these are different sets of intellectual properties. And see in this box, there are different sets of intellectual property. In one block, there is a aesthetic look of different articles. In another block, you can find some plant varieties. So there are some breeders' right for such plant varieties. In another box, you can see the integrated circuits, the designs. Another circuits, you can see the service mark, goods mark. So there are different kinds of intellectual property. Now, as per the kind of intellectual property, there are respective intellectual property rights. So for our innovative products or process, we have system to protect such things either in patents or utility model. In India, there is no any utility model laws. In certain countries like China, Japan, there is a utility model provisions also. Patent is given for 20 years, so they gives protection for 5 to 7 years for such utility model. For cultural, artistic, literary works, there is a copyright. Under copyright, we can protect such literature, drama, music, artistic things, recordings. They are creative designs. So creative designs may be protected under copyright, but the best option is industrial design rights if we need to commercialize such creative design over certain article. Because if we manufacture such article more than 50 copies, copyright exhaust. So we don't have copyright, we don't have industrial design after 50 copies. So our legal rights exhaust. So safer side, I recommend don't think that copyright is enough to protect your creative design. If you wish to commercialize such creative design under certain article, better go for industrial design protection. Industrial design rights in India popularly called design patent. Although as per the law there is no any design patent word in India, design patent is exist in US. since we follow most of the time such developed country, so we import such terminology, such words from there. So many times most of the participant might heard this design patent. In India, we don't have design patent. We have industrial design. Although both these are considered equivalent, and for functional aspects, we have to go for patents, and for aesthetic or design aspects, we can protect such things not under the patent system but under industrial design. And there are same weightage regarding the numbers, how many IP applications you have filed, how many applications you have published, how many applications you have granted or commercialized. All such number will work for distinctive signs that distinct or differentiate the goods or service from different origin. Such distinctive signs are eligible to be protected under trademark. Although there is no any compulsory requirement to protect your distinctive sign under trademark, so if someone else try to pass their goods or service under your mark or deceptive similar mark, we can sue such person under passing off provision. But if we have registered such mark, we have options to sue under both passing off and infringement. So this is the difference in passing off and infringement. For microchip, we can protect it under layout design of integrated circuits laws. And under GI laws, geographical indications, those articles, those goods, whether natural goods, agricultural goods, manufactured goods, textile item, all such things can be considered for GI tag. This is one of the unique IPR which is different than other IPR in the context that anyone may apply for any of the IPR, but GI application can be filed not by single individuals but only by some society, so that all the members under that society in that particular geographical area may have such benefits of authorized user. So only the authorized user can use such tag, GI tag, and who those are not the authorized user under this society can't use such GI tag. Again, there is a confidential information, business information. We can protect it under trade secrets. As such, there is no any IP laws on trade secrets. We have patent laws, copyright laws, design laws, GI laws, but we don't have trade secret laws as such. We have Contact Act. Under the Contact Act, we can enforce our interest in such confidential business information. And lastly, there are plant varieties. So there is no any requirement to prove that this is a new plant always. So novelty is not a compulsory requirement. So there are plant breeders and farmers' right for such plant varieties. So one thing is common in all such IPR. What is the common feature? The common feature is the intellect, your ideas. So expression is different as per the kind of idea. So it may be copyright subject, it may be patent subject, it may be a trademark subject. So all such laws, internationally there are some international bodies and treaties, and India is one of the member countries in all such international bodies and treaties. And the top institutions and arrangement internationally on the IPR is like WIPO, WTO. WIPO is World Intellectual Property Organization, one of the United Nations body, and WTO is World Trade Organization. So these are certain arrangements like Paris Convention for Industrial Property, Berne Convention for Copyright. Internationally, all the countries follow all both these institutions, WIPO and WTO, and WIPO suggests 7 IPR. India comply as per the WTO TRIPS. So last amendment in patent we have in 2005 for patent. So this is the Indian system for intellectual property rights. We have office of CGPDT here. So under that all such IP office exist like patent office, trademark registry, GI registry, etc. So there are certain times branch offices. For patent there are 4 branch offices. For trademark there are 5 offices. For GI copyright there is a single office. Nowadays all such applications can be filed online. So it hardly matter whether where there are such offices, because we don't need to visit such office for the filing. Even for the hearing we don't need to visit. All such hearings can be managed online. So just like property documents, see, these are the documents for different kinds of intellectual property rights. One for patent, another one for trademarks, another one is design, another one is for copyright, and first one is on trademark. So these are 4 major IPR. This is the portal of IP office in India. So we can access all the relevant information and links from this portal for IPR. So for any IPO information, I suggest not to use Google or artificial intelligence, ChatGPT, etc. Most of the information you sought about the IPR can be accessible on this portal only. So better get the authentic information. So you may get information on IP wise like patent, design, trademark, GI. So once you click on such a tab, patent tab or design tab, you get FAQs, frequently asked questions, their manual, guidelines, all such documents you can access freely using such a portal or tabs, respective tabs. So there is an option on see comprehensive e-filing. So anyone can file online such applications, although it is not recommended because there is no any reversal in government fee, and there is a high risk because it needs a continuous follow-up, prosecution, hearing. So there is a recommendation that you must need some expert services in such IP filings, drafting. So there is option of public search. Before filing, it is recommended we must need to search, because without search, if we do it in good faith that our IP is novel, new, it will be easily accepted by such IP office. Later on, there are some objections, and there is some citations in the examination report that whatever you are filing, it is already published, already patented. So where is the novelty? So in order to avoid such future complications, objections regarding differentiations with the cited prior arts, better we do such public search before filing such applications. And it's not a rocket science. Before filing any applications, the creator, the inventor, designer, all these persons can do such search with the help of keywords, and they will get a set of data results, and they can easily differentiate their work from others' work. And I think the best person to do such public search is the applicant, inventor themselves, because you know your invention better than any other third party, the professional, the patent agent or attorneys, and you can easily differentiate your own work from others' work, isn't it? And in fact, many times we professionals need your help to differentiate how we can differentiate the cited art from your work. So all the times we request, please explain your work, please explain what is the novelty feature of your work, please explain what is non-obvious in your work, how we can differentiate your work from others' work. Although patent office don't ask any search report from you or your experts, your agent, but this is in your interest because without doing it, if we file any such application, later on you will receive the examination report and all such objections will be mentioned in such examination report. We have to respond later for such examination report. So for the filings for the numbers, anyone can file anything, no problem. And once you file anything, whether based on merit or without merit, you will get the receipt having the application number, like all such IP applications, patent application number, design application number, trademark application number, copyright application number. But what next? Ultimate, all such applications need to be published, need to be examined, and take the examination report. At that time, you have to respond how to differentiate. So regarding copyright, the problem arises after the printing press. Now it's very easy to create replica. So anyone can misappropriate or commercialize other work with the help of such printing press. So it realized the need of certain legal provisions internationally to regulate such copyright issues. So copyright is an exclusive legal rights granted to creator on expression of an idea. So idea is not protected, it's the expression of the idea. So copyright owner has right to reproduce, translate, adapt, perform, distribute, and publicly display the work. And no person without the prior authority from such copyright owner may do all such functions like reproduction, translation, adaptation, perform. Only for the academic purpose or research purpose, we can do it and we can defend as a fair use. It's not the commercial use. Further, registration is not mandatory since copyright comes into existence as soon the intellectual work is created. Now the issue arises, how you prove you are the copyright owner, how you prove you have created this intellectual work. So it's a little difficult. We have to arrange some legal documents, some supporting documents which can be taken as evidence in the court of law. So I suggest you some tips. It's so simple, so easy to prove that you are the right owner for such copyright subject. So whenever you create anything, you can record it, like you can type it, you can record, or whatever you recorded or printed, written, whatever, arrange a copy of such things to you, your address, your email. Once you do such email to yourself, or once you do India Post to such article to your own address, there is a date and time thereon, isn't it? So there is a IP Post number, a reference number, so you can track the transactions online, and email you may get the time and day over such email, posting the email. So you can preserve both this email and both this India post. Don't open the envelope. It will help later on once any litigation arises. There is no theft of the article which is not created. So once you create anything, subsequently it may be theft. But the person who theft such data and information can't prove the time of the creation. So you can easily present the actual day and time of your creation based on the India Post record or email. But no other person can prove such earlier date and time. So you can prove that way originality and your rights in such copyright subject without any cost. There is hardly any cost. So no need to go for copyright registration. You can use this symbol copyright C under circle, all rights reserved over the documents which is created by you. So it is recommended to register a copyright for better enforceability. So there is a government fee 500 rupees. You may apply copyright online. So you will enjoy the certificates and you no need to arrange any evidence later on due to this copyright certificate. So it's up to you whether you are interested for copyright certificate or whether you can use such tips to prove your rights. So these are different subjects under copyright subject, like literary works. It may be software. In India, software is considered literary works. In some developed countries, software is considered invention, like US. Software is considered invention. In India, we don't consider software as an invention. Here in India, we consider literary things. Books, essay, compilation, computer programs, artistic things like drawing, painting, logo, map, chart, photographs, work of architectures, all such things comes under artistic, musical, notations, cinematographic film, recordings, visual, sound recordings, screenplay, drama, all such things comes under copyright. So there is a very interesting case in copyright. University of Oxford versus Ramesri Photocopy Service and Delhi University. We all know at the time of examination, all the printing or all the photocopy shop nearby academia or inside the academic institutions, there is a student crowds. Because they need to copy the important chapters, important pages. So what happened in this case, Ramaswamy photocopies shop owner served all such things in advance. He know what is the demand in exam time. So as per the demand, he arranged photocopy his own and arrange in binding form so that at the time of exam having such demand, such order can be handy. So the case is whether such action may be considered fair or unfair. What do you think? Generally, we defend that under fair use and copyright section 52, for academic use, for research use, photocopy of certain page is allowed. Try to understand. In this case, it's not the student who do photocopy, it's the photocopy shopkeeper for the commercial interest, not for the academic interest, doing such photocopy from such books is on. And the purpose is not to get enriched his academia interest, but mere the commercial interest. But in public interest and student interest, particularly in academic interest, Delhi High Court decided in favor of Rameswari photocopy services. For your information, University of Oxford, along with other publishers, planning to move appeal in Supreme Court, and there is a very high probability for the reversal of the judgment. But due to the pressure of authors and many other stakeholders, they prefer not to challenge this case in Supreme Court. So this is a gray area. You can think about it. And after that, recently in Andhra Pradesh High Court, there is a remark that since mathematical equations and science subject are a matter of fact and laws of nature, each and every person is authorized to use them without any fear of copyright infringement. So what is the matter of fact? Anyone can express such things their own. So even in class, there is a one faculty, there are so many students, and suppose many students noting such a class in class notes, see the expression in different notebooks. Expressions are different as per the author, the student. So this is the expression. This is not the only matter of fact. How such matter of fact is explained, expressed, uh, along with certain examples, case studies, etc. So this is the overall expression which need to be protected under copyright. So the validity of such copyright is whole life of the author plus 60 years. This is just like LIC slogan, life के साथ भी, life के बाद भी. Even after the life, the author family, the representative, the right holder can enjoy up to 60 years. हरिवंश राय बच्चन की पोएम पर शायद 60 ईयर पूरे नहीं हुए होंगे तो अमिताभ बच्चन आज भी एंजॉय कर रहे होंगे. Joint where authors are joint authorship. So who is the last surviving author? From that date we count this 60 years. We must use the expressions like copyright or C symbol under the circle so that public can know that this is the copyright of that person. If you don't use this expression, how you expect from a person whether you wish to claim copyright over such subject or not? So better you must mention such symbols over your property. Like trespass is not allowed. We have to write it. We have to lock our houses. Otherwise, anyone may enter. So these are some due diligence or some strategy to protect our property. Similarly, for intellectual property, our notes, our books, we have to highlight our name over such things, whether we wish to uh, regulate such things under copyright or not. And that's why nowadays there is a concept copy left. If you interested to promote such things, आराम से कॉपी पेस्ट कीजिए, पब्लिक इंटरेस्ट में फॉरवर्ड कीजिए, शेयर कीजिए. So in such cases many times we don't claim copyrights. There is a copy left. Enjoy it. So these are some common problems due to lack of clarity. Many times might be some of you have experienced that disputes over royalties or revenue sharing when content is commercialized. Most of the times in India, things are in good faith. No one bothers, okay, fine, in collaboration or without collaboration, we will share the cost. We generally don't have much hope. We means here in academia generally don't have very much hope from technology transfer, commercialization. We people are very happy in filings, and if such things is published and granted, this is great. This is a matter of fact that there is hardly any academic institutions in India those who are interested to renew their IPRs, particularly patent. Generally, they don't renew it. Why? Because they don't see much potential to commercialize. And since there is no any guarantee of commercialization without their own efforts, and no one have any interest in others' IP. So there is a gap in industry and academia. So no one knows what you have invented, what is the utility of your invention. You don't approach to industry or other person to commercialize for technology transfer, but you need to maintain your granted patents. In order to maintain, you have to pay renewal fee every year. So in order to avoid such unnecessary burden of renewal, many times people don't renew their IPR. In lack of such renewal, such patent lapse, and once such things are abandoned, there is no any legal rights. Now anyone can use it commercially. You can't stop them. And once there is a commercialization, now there is a dispute. Who will share how much? Whether it's the 50-50, 40-60, 30-70, and it's very difficult to argue with the institutions because see the employer relations. Employee is not in dominant position. So later on, there are complex cases. So restrictions on faculty reusing their own material after leaving the institution. Again, generally in academia, applicant is the institution. And without having IP policy, having all such clear-cut guidelines, university restricting their own employee, no, this is university property, this is university publication, this is university patent. So you can't use it just like your own material. We paid you salary, you are our employee. So this is your duty to write, to publish, to create, to do research and development, to file patent applications. So you are the creator, inventor. This is okay. But you are not the owner. Ownership goes to the institution. So once such people left this organization, joined some other organization, it's very difficult for them to use their own material. So institution claiming full control over online courses content developed by faculties. Nowadays there are MOOC, SWAYAM course. So all the time such institutions have such control. Although all such creations are made by their employee, it's not the institution. Institution is not a natural person. It's only the natural person, you people, can create something. So difficulty in licensing or sharing open educational resources due to unclear rights. So best practice to resolve some of such problems, like adopt an institution IPR policy, clearly define ownership of faculty generated contents, address rights over teaching material, MOOC and collaborative content, Use author agreements on declaration, especially for funded projects or publication contract. Clarify rights in employment contract. Define what is owned by the faculty, what is owned by the institution. Introduce creative common licensing option where the faculty is interested to share such content online without any such a licensing arrangement. So creative common. Define revenue sharing models. So now see this scenario, there are different scenarios. And see as per the scenario, who are the possible copyright owner and what kind of confusion arises. Now if see there is a faculty who write a textbook or research paper independently. So the question is who will be the owner, whether the university, the organization, or the person like you. So scenario is very clear. It's the faculty who write a textbook or research paper independently. So the word here independently. So without any aid or help from the institution, if you create something, you are not the creator, but you are the owner also. So there are two words, creator and owner, author and owner. The same person may be both, and in some case, they are different person. So in second scenario, faculty creates lecture slides, videos while teaching a course. So while teaching a course, so this is under obligation. This is a part of duty. So whatever the creation creates by such faculty for such lectures or teaching a course, him or she is recognized as the author, no problem. But regarding the ownership, it's the institution. Now see another scenario: faculty develop a MOOC or SWAYAM Coursera using institutional resources. So with the help of resource material, infrastructure, library, if faculty develops such things, so in case either the institution or it may be jointly applied. So ownership is joint. So many times such dispute arises due to not having clear-cut policy, institutional policy. Now, collaborative research project with multiple faculty, external sponsor or students. So we must refer some good policy guideline of some good institution so that we have better understanding in our local institutions how we may move forward. Many times we heard these two words, plagiarism and infringement. I'm having too many slides. I covered hardly 10% so far. So if you like to interact, we can skip some slides. I believe you must know differentiation in plagiarism and infringement. Many times there's something which is unfair. Sometimes these are not illegal. Similarly, plagiarism may not be considered illegal, but this is unfair. And this is considered academic misconduct, and for that there may be disciplinary action against those persons who indulge in such unethical activities like plagiarism. So this is considered professional misconduct or academic misconduct against an infringement, that is commercializing others' property without prior consent. But in plagiarism, there is no any commercialization. It's using others' property in the way that a visitor, the reader, may be an impression that it's you who have written it. So the source, the inspiration, you have to highlight in your writer. Otherwise, if you do paraphrasing without highlighting the source or reference, your such act is unethical and part of plagiarism. So this is one of the recent notification from uh, copyright draft rules. So regarding the payment of license fee. So notwithstanding anything contained in any other provision under this rule, the owner or license of literary work, musical work, and sound recording shall establish and maintain an online payment mechanism for the collection of license fee payable by a licensee for communication to the public of such work. So this is to regulate misappropriation. So there is no literary work, musical work, and sound recording. So public feedback is invited by the ministry. Uh, So it's one of the suggestions that why certain subjects are left out, like cinematographic film work, dramatic work, performers right? Why there is no any online payment mechanism for such? And similarly, if you have some ideas, you can submit such ideas to the concerned authority. So now, other than copyright, I'm moving forward to other IPR like trademark. So just guess some of the Indian brands. Since it's difficult to interact here, so I have arranged some top brands in India: Tata, Infosys, Reliance, HDFC, Airtel, Mahindra and Mahindra, Asian Paints, Godrej, Maruti Suzuki, Wipro. Okay. So can you guess the value of all such brands? Any idea? So see, these are the some of the top brands, and see the tools they used, like they have presence in multiple countries. They are dealing with several products, sometimes in services too, and see the brand value in US dollar, and all such data are in billions. Although these are tentative data, so Tata Group's estimated brand value is around $27 billion. And see the brand value of some other top Indian brands like Infosys, $13 billion, Reliance, HDFC, Bharti Airtel, Mahindra. So all such are in US billion dollars, multi-billion dollars. And this is only for their goodwill, their brands. This is not cover any tangible property. It's not cover their lands, their infrastructure, their machinery, nothing. Neither of the stocks. It's all about their brands. Hope you got this point. So what can be a trademark? Trademark can be anything. Literally, it can be anything subject to there must not be any confusion among the public regarding the source of your goods or services. So it may be a name like Bajaj, Haldiram. These are the names, surnames, invented or arbitrary words. Samsung. So this is an arbitrary word. There is no any dictionary meaning. Letters, numerals, monogram. So device including fancy device like Microsoft, combination of colors or even a single color like Cadbury, Toyota. Okay. I just realized it's around 5. So I have to move forwards. I have to cover a lot of things. So so I'm come to yesterday incident. See the Boeing 787 at Dreamliner. You know, uh, this is the first ever fatal crash since its introduction in 2011. This Dreamliner introduced in year 2011, and there since then there is no such incident. There may be some minor incident like battery issues, AC issues, but there is no any casualty. There is no such accident. So this is the first time for particular this model Boeing 787 at Dreamliners. And see the company annual revenue. Last year, this revenue is $66.5 billion, and see the market capitalization. There are several other models with this company. There is so much innovations. So this is not the fault of this model. There are some other reasons. Maybe human mistake or some other reasons. So see this case study from the angle of IPR. There are so many IPR linked with this product, and there is a huge commercialization. So it's too motivating. Without IPR, such company can't create, can't invest for such wonderful uh, innovations which served humanity so far. So this is one of the safest mode of travel. So challenge in patenting. So these are certain challenges. Low patent awareness among researchers and faculty despite high quality research output. So many times it is noted that in academia they have very good quality research output, but they are unable to arrange such information for the purpose of patent. And due to lack of uh, based mode disclosure in their patent specification, it's a later very difficult to manage amendments request to cover all such missing things in your specification after filing. So no formal IP policy in many institutions, lack of funding and expertise for prior art such as drafting, prosecution, filing patents only for academic credentials. So there is some sort of number game. So many times we are interested for filing only. We don't have trust or believe that such applications may be considered by IP office. And even after consideration by IP office, we do hardly much for commercialization of such file application. So see, this is Kapila scheme. Under this Kapila scheme, up to 100 patent applications is allowed by every institutions, and whatever the government fee for filing, request for examination, all such fee are reimbursed by uh, Ministry of Education under this Kapila scheme to such respective institutions. And again, there is a different scheme like TISC, TISC. Under that, if you request such a help, they will arrange you free facilitation of drafting such report. So you no need to pay any professional charges. So whatever you paid, that is government fee, that you can claim reimbursement on, and whatever the professional charges, you no need to pay under TISC scheme. So combining both Kapila scheme and TISC scheme, there is a zero cost for patent. And under such a scheme, you can get benefit of 100 patents every year per institution. So this is cost-free patent to educational institutions. So this is regarding the design. Why design I covered under this presentation. One of the main motivations adding this design part in this presentation is, see, we covered 25 years. Design law in India comes in year 2000. So now in 2025, we cover 25 years, the journey of industrial design. And these are some of the features like novelty is now accessed on a global basis. India becomes signatory to Locarno Agreement, which is for international classification of industrial design, inclusion of MSME sector and a startup with corresponding fee reduction. So government is giving 80% discount to MSME and startups. Nowadays, since last year, academia too, 80% discount. So industrial design, they are also giving 80% discount to small entities, including MSME, startup, and academic. So this is one of the public notice issued in May 2025, where Office of CGPDTM is announcing the celebration of 25th anniversary of enactment of Design Act. So additionally, this office encourages stakeholders to share their success story. If you like, if you have some success story regarding industrial design on this email ID controllerdesign.ipo@nic.in, you can share. Maybe such a success story is published by IP Office of India. So these are some of the challenges to protect industrial design. One is the negligence in protecting innovative product or interface design by a student, confusion between copyright and design protection, lack of support for filing design applications, no institutional mechanism to identify and screen a student prototype for design. So for every IPR, we can discuss such challenges. So there are different criteria, there are different process to hire and follow up such IPR. Similarly, this is another interesting IPR geographical indications. So far, we have around 1600 JA applications. Most of the applications are under process, and around 40% applications filed so far are registered. So these are some of the food items, famous food items, which are GI tag, like Bengal Rasgulla, Bikaneri Bhujia, Andhra pickles, Varna Srikhand, Agra Petha, Kota Kachori. So all these are not GI tagged items, but these are potential GI. Some of such potential GI are GI tagged also, and these are some of the GI tagged handicraft items. So these are different kinds of GI tags item. Maybe food item, maybe handicraft item, maybe a textile item like Mysore silk, loose salt, maybe a natural item like Makarana marble. Taj Mahal is made by this Makarana marble. So these are different categories of GI: agriculture, food stuff, handicraft, textile, manufacture, natural. This is another IPR semiconductor indicator circuits. So we need to protect it. This is another one, domain name. So there are a lot of IP issues related to bioresources and the associated traditional knowledge. So this is one of the government scheme SIPP startup intellectual property organizations. So confirms that own intellectual property rights on average 20% higher revenue per employee than others. Awareness for IP is the key to gaining competitive advantage of technological gain for achieving higher economic growth. So contribute to IP, be innovative, think outside the box. These are some of the useful links. You can take a screenshot. You can access such portal to get more such useful information on intellectual properties. So thank you so much for listening to me for so long.
Thank you very much,
So
sir.
please feel free to ask questions if any. Thank you all.
Thank you, sir.
Thank you, sir.
Thank you, sir. Thank you.
Thank you so much, sir.
If you have any
Thank you
question,
very much,
please feel
sir.
free to. If you like to interact, please feel free to ask any questions. You can write in textbooks also.
Sir, please mention about 9394 registration, about patent.
93
94 registration.
9394. What is 9394?
Patent of registration. 9493. If any product patent after 20 years, if take patent to 94 registration. 93 after the 20 years patent of about this some knowledge give me.
What I understand, you are asking patent term is for 20 years. After expiry of 20 years, can we renew such patent or not? Whether I understand your question or not. So regarding renewal, there is a maximum term is 20 years. We can't renew it further because
Yes, sir.
evergreening is not allowed.
Yes,
So
sir.
this is a balancing system. If we continue renewing it, so the right holder can exclude others perpetually. So this is not allowed. Maybe I am able to understand your questions. So can you clarify?
Sir, may I interrupt here?
Please.
Because of the shortage of the time,
Right.
we have to wind up the session so very hurriedly. And may the participants may take their queries afterwards. Maybe we will provide your email ID to the participants so they can directly reach to you. Okay.
No problem.
Yes, sir. Okay, so thank you very much, sir, for the deeply enriching and insightful session. Your words has given us much needed clarity on the complex world of intellectual property rights, and most importantly, have empowered us to approach our work with both creativity and a legal caution. We are grateful for the wealth of knowledge you have shared with us. Thank you so much, sir. Now, I feel privileged to invite our guiding force and visionary leader, the Honorable Vice Chancellor of Nirvan University, Professor S.L. Godara, to kindly address the gathering and share their words of wisdom. Sir, may I request you to please take over?
Thank you, Madam Diana. This webinar is organizing by our university, Nirvana University, and the seminar is organized under the umbrella of our university, Nirvana University, Jaipur. First of all, I thank Dr. Pankaj Kumar ji for detailed lecture on this IPR, because this topic is very important now in present era, and in every field. Even copyrights, and you have mentioned in your lecture plagiarism, designs, patents. These are very important topics, and now every field have facing this type of especially in research plagiarism. It is very important aspect, and you covered very in details. And the topic is very important in the present scenario. And especially, I thank Dr. Pankaj Kumar ji for accepting our invitation. Because Dr. Reena Anand requesting to manage this webinar. And I think 300 to 400 participants have attended this important topic at your lecture, sir. It's Nirvana University Hall with the faculty members. I'm very thankful for your insightful lectures on this PR industrial designs. Challenges for researchers. your expertise and sharing of knowledge are very invaluable, sir. You have explained through your slides in details about the whole category of IPR. And this topic is very lengthy, and you explained in very beautiful manner. You have covered all the categories, the trademarks also. All the categories have their own acts, and this IPR starts from 2000. And nowadays, these patents and geographical indications are very important. You mentioned in your, I think in your last slides, this Bikaner Bhujia and the Mendi of this Jalo and other patents or tagging or geographical indications of different areas. Once again, on behalf of the Nirvana University, more and I think that especially Pankaj Kumar ji, for valuable lecture on PR and university design challenges of research. I think Dr. Reena Anand and Madam Daima for organizing this webinar. And I appreciate our university technical and IT cell for organizing this webinar in a very good manner. I thanks again. I thanks Dr. Pankaj Kumar. Thank you, sir.
Thank you, sir, for the opportunity.
Okay, sir.
Thank
It's
you,
really great to serving you people.
Thank you, sir.
Thank you, sir.
Madam Daima, please proceed.
Thank you so much, sir, for your inspiring address. As we conclude this enriching session, I would like to invite Dr. Reena Anand, Associate Professor, School of Library and Information Science, for the vote of thanks. Ma'am, please.
Good afternoon to all. Good afternoon to all. It is my great privilege and honor to extend the vote of thanks as the convener of today's national webinar on IPR and industrial design challenges for researchers, organized by the School of Library Information Science and Gyan Central Library, Nirvana University, Jaipur. First and foremost, I extend my sincere gratitude to our Honorable Chairman Sir for his visionary leadership and continued encouragement, which always inspire us to achieve academic excellence. I sincerely heartfelt thanks to our Honorable Vice Chancellor Sir for his continued support and for creating a positive environment for innovative and research at our university. We are grateful to Sir for taking time out of his busy schedule to join today's webinar and for inspiring us with his kind and motivating words. I sincerely thank our esteemed registrar sir for always motivating us to achieve our goal and contribute meaningfully to the growth of the institutions. Even with his busy schedule, sir took out time to be with us today, and we are truly grateful for his support. I sincerely thanks to the resource person, Dr. Pankaj Kumar sir, Chair Professor, for accepting our invitation and giving us such a useful and throughout talk. Pankaj sir explained topics like IPR, copyright, patent, and industrial design in a very clear and simple way. He always told us, he also told us that in the NIRF ranking system, IPR has 10 marks, which show how important is it for universities. We are truly thankful to him for sharing such valuable knowledge with us. I extend my warm thanks to all the faculty members, students, and research scholars of Nirvan University for their active participation. I also thank all the participation for different part of India for joining us for making this event successful with their presence. A special thanks to our webinar organizing team. I sincerely thank my co-convener, Dr. Jyotsna ma'am, Mr. Lokesh sir, and Mr. Vivek sir for their great efforts and technical support. Because of them, the webinar was conducted smoothly. Last but not least, I thank everyone who contributed directly or indirectly to the success of this webinar. Thank you once again to everyone to your valuable time and support. Now, I request everyone to please turn on your camera for the group photo. Thank you.
कंक्लूड हो गया मैम?
Yes, sir. Group photo होगी sir आपको एक group photo please. Now I request everyone to please turn on your camera for group photo. I request to all of you, please turn on your camera, please. Thank you once again to everyone to your for your valuable times and support. Thank you so much. Thank you so once again, Honorable Vice Chancellor sir, and thank you once again, Dr. Pankaj Kumar sir, today's resource person. Thank you, Jyotsna ma'am.
Thank you all.
Thank you,
Thank you,
ma'am.
ma'am.
Thank you.
Thank you, ma'am.
Thank you, all of you.
Thank you, ma'am.
Thank you, ma'am. Thank you.
You can leave now.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am. Thank you, ma'am. Thank you, ma'am.
Thank you, ma'am.
Thank you so much.
Thank you,
so
ma'am.
Thank you, ma'am.
Thank you for such an informative session, ma'am.
आपके लिए हम जल्दी एक और सेशन लेके आने वाले हैं. इट्स वेरी इंपॉर्टेंट फॉर ऑल रिसर्च स्कॉलर. हम आपके लिए जेगेट नेक्स्ट का सेशन लेकर आएंगे, तो आप डेफिनेटली उसको भी ज्वाइन करिएगा. तो आपको काफी कुछ आप सीखने को मिलेगा आपको. ठीक है, जल्दी ही हम आपको इन्फॉर्मेशन शेयर करेंगे.
Ma'am, good evening, ma'am. How are you, ma'am?